The following is an informational program from the Sangamon County Circuit Clerk's Office. The information contained in this program is solely for the use of the people of Sangamon County to make them more aware of the services of the Circuit Clerk's Office. The employees of the Circuit Clerk's Office cannot give legal advice. Hello, ladies and gentlemen, and welcome to another edition of Circuit Clerk Presents. My name's Paul Palazzolo, your Sangamon County Circuit Clerk, and a huge shout out to the students of the Capital Area Career Center and the students at the digital media class and their instructor, Paul LaMantia, for providing the studios and the filming that's helping us present this program to you today. This episode's topic is on wills and probate. And it's a very important topic because we may not be thinking about something that might happen down the road, that we might need a will, but having a will and the elements that surround that topic are amazing, and we need to know about them so that we can be prepared. So that's why today's topic is wills and probate. And with me is Nancy Martin. She's an attorney with Graham & Graham Law Firm at 1201 South 8th Street in Springfield. And their phone number, and we'll mention this again, is 523-4569. Nancy, tell us a little bit about yourself and your background and how long you've been in the legal arena and how you come to become an expert in wills and probate.
Okay. Well, as Paul said, my name's Nancy Martin. My background is actually a rather business-oriented background. I went to the University of Illinois and graduated with a finance degree. Went down to SIU in Carbondale and got both my MBA and a law degree, and did with the MBA accounting concentration. So when I graduated, I began my career with Graham & Graham in 1986, and with my business background, found that I worked a lot more with income tax, numbers, estate planning fit right in there, because a lot of times it went dovetail or hand in hand with estate planning kinds of issues, particularly back when we had a much lower estate tax credit. So anyway, while I do many things, I do spend a lot of time with wills and probate and guardianship and other things that are part of the probate arena. And that's, that I've been there since '86.
Wow, that's a long time at one firm, and that means you must do your job well. And so we're glad that you're with us today. And particularly, as I mentioned earlier, it's a very important topic that we need to be prepared for. So kind of let's start with the basics. What's the difference between a will and then probate, and how does that fit into what folks are going to be needing to do?
Okay. Let's take the second one first, probate.
Okay.
Probate is just the formal process of administering any estate. And as we know, some people die having a will and some people die intestate or not having a will. In fact, testate is just the person who is saying what they want to have happen with their stuff. So if you die without a will, you're intestate, meaning not have a will, and you're testate if you have a will.
Okay.
The probate process, as I said, it applies both for those who have a will and those that don't have a will. It's a formal judiciary process. If you have a will, while it's a very valid, legal, presumably it meets all the requirements if it's done properly, a legal document, however, it has no binding effect until a judge says, I'm admitting it to probate. Okay. So it's a common misconception. A lot of time people just expect, well, I have this legal document, so everybody's going to honor it, or I'm going to be the executor because I'm named in the will. You don't have that legal authority until it's admitted to probate. It's beyond what we want to talk about today, but there are some times where you don't have to necessarily probate a will in order to have the will carried out. Yep. And some folks are familiar with the concept of a small estate affidavit, and it's what I kind of consider an informal probate. But as I said, we won't touch on that now because we'll be into a whole different arena. So anyway, probate is the formal judiciary process of administering an estate. A will is, as I said, it's a legal document. It basically outlines your estate plan, what you want to have happen with your, I call it stuff.
Sure.
Whether it's real estate, whether it's bank accounts, brokerage accounts, the stuff in your house, it's whatever you own. and what you want to have happen. A will also often includes, if you have minor children, who it is that you would want to be the guardians for your minor children should both you and your spouse be deceased. It may also provide for a trust that could take care of perhaps a spouse who has some infirmities, or there may be a family member who's got some special needs that it's planning for, or sometimes family members don't maybe have the same financial abilities as their parents, and so I have included provisions for those sorts of children or relatives that the parents want to make sure that somebody's going to be the safekeeper of the money,
Sure.
So that it lasts a little bit longer. So there are different reasons to incorporate a trust. Then, of course, the will also would say who's going to be the executor. Who is going to be my legal representative when I die, and therefore act in my stead to collect what I owned and to make sure my bills and my debts and everything's paid, and then at the end of the administrative period, distribute it in accordance with the terms of the will. An important thing to note, though, about a will, and it's a very common misconception. I've even had to explain this to attorneys who are in the criminal law practice, fortunately not the probate practice, but the criminal law practice where they don't deal with wills all that often. A will only controls the things that are just in your name when you die. So if you have very carefully put your children on all of your assets as a joint owner, or a payable on death designee, or a transfer on death designee, or a beneficiary, the will not control what happens. And I know that, as I said, I've had this discussion many times with clients and friends and associates, that just because your will says, I leave everything to my 4 children evenly, or equally, if I have only put 2 of my children as beneficiaries on an insurance policy or the IRA, that passes outside of my will.
That supersedes.
Correct. It's also why frequently when there's a married couple, typically the will provides, again, the usual way is for spouses to say, look, I want to leave everything to my spouse when I die. Then, if my spouse dies before me, then we'll start talking about it's going to the children or the grandchildren or whoever. So when the first spouse dies, it's very common not to have to probate the estate for the first spouse that died, because chances are the spouses are the beneficiaries on their insurances, the IRAs.
Everything's already covered then.
Exactly. The house is joint. Basically everything just becomes the second spouse's automatically because of those contract provisions, which are the joint tenancies or the payable on death designations, transfer on death, all those kinds of things. It's not to say it always happens, and so every now and then you run into an instance where, no, there is something that one of the spouses had just in their name, and so then we just have to address whether or not, how to go about getting it, whether we have to go through formal probate or there's another way to get it into that spouse's name.
So Nancy, who can make a will and who should make a will?
A will is a legal document, as we said, and it's basically the same requirements as to make any contract. So you need to be 18, and you need to be legally competent. And by legally competent, for purposes of making a will, it's a rather low threshold. You just have to appreciate, understand who you are, who your family is, the people you normally think that you would leave assets to upon your demise, although it doesn't mean you have to, but you understand that if you leave somebody out, you're doing it so consciously, not because somebody's making you or because you forgot you have kids, kind of a thing. And you have to have a kind of an appreciation of what your stuff entails. I have real estate, I have farm ground, I have a bank account, I have a brokerage account, whatever. You don't have to be able to... Comic books, there you go. Yes, I have depression glass candlesticks, many, antique children's book, that kind of stuff. You just have to kind of have a sense of what you have. You don't have to know exactly what you have. I once had an elderly client, and she knew she had significant assets. Well, she was fortunate during the 80s. Her portfolio exploded, And she had no concept of the actual dollar figure she had, but she knew what it was she had. So that's okay. She can say where it's going to go, even if she doesn't truly appreciate it in current dollars. So anyway, yeah, that's basically to be, conscious and understand these sorts of things, and be able to say, I want to do this, and be able to formulate a reason why, as I said, why I'm doing this, why I'm leaving this person out, or why I'm including this person who maybe you wouldn't necessarily think about including. And as far as who should have one, in my opinion, everybody. Even if your plan is, and again, I've had folks who say, well, I'm just going to put all my kids on my CDs, and that's my plan. It's just going to all be theirs when I die. What if they decide to move the CD to a different bank? What if somehow a beneficiary designation doesn't make it to the insurance company and they don't recognize it, or you're in the last hours of your life, you're faxing the beneficiary designation to the company, and then only to find out after your parent passed away, they're going to reject it because of some technicality. It wasn't dated, it didn't come on the right, whatever. To me, a will is that safety net. I think of like the trampoline artist. And that way, you've got that just in case there's something that fell through the cracks. There's something that you forgot you had, and it's going to direct where it is that it should go.
I'm glad to hear there's a low threshold for, who can do it. Do I need an attorney to get a will?
Not necessarily. There's a lot of do-it-yourself kinds of kits out there. Certainly online. Some office stores, I believe, have them. It's just important to make sure that somewhere in the information you're receiving, that they do, that they report that somehow there's been some level of scrutiny by the form by an Illinois professional. Somehow they say, yes, this meets the criteria of Illinois law for wills, what wills need to have in them to make them legal and binding. I don't like to see people do those things.
Sure.
However, it's better than nothing.
Yep.
And I think it's a good place to start. It gets people sometimes thinking about the different ideas, issues, but I believe it would be best if folks take what they've done and at least ask an attorney to review it with them. Because a lot of times when people write their wills, they think about who the players are today. And because, again, from my own experience, I find that when I say, now, what if your son dies before you? And I get this dead look. Oh, I didn't think about that. Well, doesn't it go to his wife? No, it doesn't go to the wife. The wife's not a blood member. You explain all these things. Here's what happens if you don't provide. What happens if your son dies first? Here's what happens if your wife survives you and remarries. Here's what happens. You go through the different kinds of contingencies. And then a lot of times it gets the client thinking about things they hadn't thought about, and realizing that there may be consequences that they didn't intend. And so then when they express what their concerns are about that scenario, you can then draft the will to accommodate or cover those kinds of instances. Now, you could write a will that's the size of the Bible and cover every possible contingency out there, but that's not advisable either. You basically plan on writing your will for if I die tomorrow kind of a thing, and we don't want to have to rewrite wills all the time.
Right.
So in the recent, or I shouldn't say the recent, in the likely near future, you cover the basics, like if a child dies before you, if you're the second to go between you and your spouse, some of these sorts of things, the most likely contingencies, if you will. Then with the notion being that if something drastic happens, all my children perish in an accident, or I have unwed children with children and grandchildren, and we don't really care for how they're being, all those sorts of things that come back in later, and then rewrite your will to address those oddities that maybe when you were sitting there you just didn't expect, or so your child has an accident and becomes a paraplegic, and now suddenly you don't want to leave money directly to them. Now we're talking trust. So you're not necessarily designing it for all those extreme contingencies, but just kind of the normal ebb and flow of the family life.
I think it's important to note that you don't necessarily need an attorney, but it's always advisable to make sure that you've got somebody there to
Correct.
help you shepherd through that
Certainly.
will production process. Again, fascinating topic, wills and probate. Thank you for being with us. Let's take a short break, and we'll be right back. Welcome back, ladies and gentlemen. Again, another episode of Circuit Clerk Presents. My name is Paul Palazzolo, your Sangamon County Circuit Clerk, and again with me is Nancy Martin, an attorney with Graham & Graham here in Springfield. And today's topic, wills and probate, again, a very important topic, particularly if you're going to be prepared for any incident that might occur in your life, your family's life. And Nancy, what happens if a person dies without a will?
If you die intestate
Yes.
without a will, the law has a backup plan, if you will, a default provision. So if you don't have a will and you're married and have no descendants, no children, grandchildren, etc., then everything belongs to the spouse.
Automatic.
Automatic. However, and this is, again, where married couples typically write a will leaving everything to the other one, because if you're married and you have children or grandchildren because your children are deceased, and so you do have descendants, half of your estate belongs to your spouse, the other half belongs to your descendants.
Okay.
In the event that you die without a spouse, without a legal spouse, of course, now we have to remember we've got the domestic union kinds of things.
Sure, sure.
So it's not necessarily the traditional spouse, but anyway. If you have no legal spouse and just children and grandchildren, then it's like the roots of a tree where you count up how many children there at one time were, and if you divide it by how many children there were, and you stop when you get to a life. So if a child's alive, that's one share. If a child is deceased and left two children, well, those two children take that share, and so forth.
Wow.
In the event you have no descendants, maybe you never married, never had children, and then die, or you're just single when you die, then you start looking up to your parents. We had a rather interesting situation one time where the young woman, she was single at the time of her death, never had any children. Her mother was alive, but her father had died within 6 months of her death. Mother received half the estate. The other half, we had to track down Dad's heirs. And he had a really colorful past. You know, he had some children out of wedlock, some children in wedlock, some children he'd given up rights to. He adopted a stepchild or two. So it really made it interesting. Exactly. The unfortunate thing is chances are that this young woman, when she died, she really wanted everything to go to her mom and her stepdad, who had pretty much raised her. Mm-hmm. But she didn't have a will. Okay. So that's not the way it ended up going. But there are default provisions, and so that way, eventually somebody will get your stuff. I know a lot of people think if you don't have a will, the state gets it, but the state really only has a claim on it if you seriously have no living, breathing, blood relative.
Wow. Again, it's so important to be prepared. Can a will be revoked or changed?
Yes, as long as you have the capacity to do so. Again, as long as you're competent to make it, you're competent to revoke it or change it. Revoking it is just the simple act of burning it, obliterating it, tearing it up, whatever. And changing it, in the old days, before computers, you actually did what we call a codicil. And you typed up a document very similar to the will. It had a lot of the same things on it, but it just said, section 2nd, paragraph A, yeah, I want to change that amount, or I want to strike that, but I want everything else in that original will to be the same. It made for an older person who had died and done numerous codicils. It was kind of like putting together a jigsaw puzzle, because you had to start with the will, and then you had to find all the codicils and then figure out what it was different. Fortunately, this day and age, with computers, it's wonderful, because then you're just better off in just rewriting the entire will and just say, here's what it is today and here's what it's going to say.
Does everyone need a living trust?
No. A lot of people are starting to use living trusts, and there's definitely advantages to using them. Just for people who know what I'm talking about, you also hear the term inter vivos trust. It's a Latin phrase that means created during my life. There's basically two kinds of trusts. inter vivos, created during your life, and testamentary. Those are the ones that are created by the last will and testament, and those don't take effect until obviously you die, because that's when the will is admitted to probate. You don't have to have a large estate to make use of a trust, but you do, if you're going to create a living trust, what you do have to do is fund it presently. I mean, you need to change the asset. So if you've got real estate, you need to make sure the trust owns the real estate now. If you've got, if you want to put bank accounts, the trust needs to own it now. And there's reasons people like to do that. It's kind of like establishing your trust while you're alive. It does make for an easy transition because the trustee, not your executor, ends up finishing up your affairs and distributing it the way the trust says to distribute it. And so you are finding that they're more commonly used than they were before, but no, everyone does not need it, and some folks are comfortable using them and some people aren't.
When would I then file a will with the Circuit Clerk's office, our Sangamon County Circuit Clerk's office, where I serve citizens of Sangamon County?
Regardless of whether the will needs to be probated, there is a law that says you must file a legal will, if you are in possession of it, with the circuit clerk of the county in either where the person resided or where they died. And then, as you know, your office keeps it for eternity. The person who's filing it can certainly request a copy, or I typically take copies and then just ask your office to file stamp them so I know what I took and delivered and when I took it. And so, there's no, the statute would suggest, and I have to admit, I don't remember if it's 60 days or 90 days, but there's a time period where the statute says, thou shalt file a will with the circuit clerk's office. However, people don't always find them that quickly.
Right.
And so whenever you do come across an original, you should go ahead and file it with the office. And it seems silly because if you're not probating it, but on the other hand, we have run into it many times where years after the person died, suddenly then there's a problem that's discovered, and then nobody knows where that original will is. And it's possible the original will got destroyed.
Yeah.
If they had taken it to the clerk's office, then all you have to do is go down there, and if you didn't keep a copy, you get a copy there. But you know what it is, and you know what it said, and you know where whatever this miscellaneous piece of stuff is, you know who it belongs to.
And that would at least have been on file, and that way you didn't have to worry about it. Now, that would go for whether it was done by an attorney or whether you had one that you had done on one's own, correct?
Correct. Yeah, the statute doesn't differentiate who prepared the document. It's just if you are in possession of a valid last will and testament when you know the person died, you have an obligation, a legal obligation. There's even criminal penalties associated with it, that you have the legal obligation to file it.
Now, earlier we talked about the benefits of having an attorney work with you in creating the will. Where would you, if you did one on your own, a will, where would you find the do-it-yourself form to make that happen?
Honestly, the ones I'm most familiar with are on the internet.
Okay.
And I couldn't even direct you to a specific website because I don't go looking for them.
Sure.
But I know from time to time, just to see what's out there, I've surfed and kind of looked for some things. It's possible Department on Aging, sometimes they have some legal forms that elder people might be interested in. They may, but honestly, I'm not positive. As I said, once upon a time, you could find some of those in office supply stores or places that have form documents. So that's a possibility.
If you're really interested in doing something yourself, you should probably go to a website on the internet that has a bit of a reputation rather than just a site that you find, at least either a state-sponsored site for the Department of Aging or an office supply store, as you mentioned. Goes to something reputable instead of just George's template wills or something like that.
Correct. And something like, I think there's legalzoom.com or some such thing I've run into. And I believe when looking for some odd document for a client who's moved out of state to try and kind of help them, it seems to me that they also are pretty good about representing what states and what level of review they have done. So yes, you want to look into kind of the credentials of who it is and what it is and to try and get some what do I want to say, feeling that what you're doing is actually going to be, it's going to hold
valid.
up.
It's going to be valid.
Correct.
And so a bit of a final question. We talked about the ability to change a will, and you have to be of sound mind and a low threshold for that. What would be the causes or the considerations for changing a will?
Okay. The first thing is that because age does not alone invalidate the will. I know folks will call up and say, oh my gosh, my will is 20 years old. It's not good anymore. Well, no, it's fine. The question is, read the will and see if all the provisions still apply. Now, I understand maybe that spouse has already passed away, but if what the will says happens in the event of the earlier death of your spouse, is that still effective? Where a lot of times people want to change it is because they say, well, you know what? This child now has grandchildren, they didn't have them before, and I want to provide that if my daughter dies and she has children under the age of 21, I want their money to be held in trust, and here's who I want to hold it in trust. Or they take a look at the people who they've named as executors. Well, it may be that some of those people have died, some of those people themselves are of advanced years or in poor health. So there's circumstances in the will that have changed, just the players have changed in the document. Then there's also those sorts of things that have happened in lives. And it may be the case we alluded to in the other episode about a child has had a traumatic injury. Or maybe now you've had time to see that this child isn't such a financial wizard. Or maybe they're a bum magnet. I hear that a lot. And they're concerned about what's going to happen to their money, and all those good stories. Or maybe they're starting to worry about what if I have some health problems and so I'm likely to die before my spouse, and what if that spouse should remarry? Assets may have changed as well. It used to be people would update their wills to try and accommodate the different estate tax law to do some estate tax planning with much higher credit shelter amounts. That's less of a concern. But now you're finding that there may be some reasons to do some income tax planning to try and help with those various assets and whatnots. So it's just people's lives change, and it's a good idea from time to time to take a look at it, to remind yourself what you've done. Take a look at what your family situation looks like, or your friends, or whoever it is you want to remember, and see if what you've done is still, if you died tomorrow kind of an event, is this what you would
Still
want to have happen? Right.
Dust off the will then.
That's right. And along with it, usually then, that's a good time to also be remembering and to check with your insurance companies or your brokerage, or whatever assets you have, to double check with them, who do you think the beneficiary is? Because now insurance companies have been doing kind of what the banks did years ago, where they're all merging and selling and changing. And what if you sent in a beneficiary designation form that somebody's lost track of? So it's not a bad idea every once in a while, just like what does your will say is going to happen, those other things that you've put some beneficiary or TOD or whatever designations, oh, by the way, who are you planning to pay this out when I die too? And make sure it's still what you want to have happen. And just because you named, say you had 4 children, and you say my 4 children are the beneficiaries of whatever, you need to also check with the current policy from the company. What if one of those 4 have died first? What happens to their 4th? Typically what I hear is, well, it just goes to the 3 who are alive. Families don't always have that in mind. They just assume, well, if one of my children is deceased, I want my grandchildren to take their share. So again, it may cause a need to rethink even your beneficiary designations. That also may mean, in one situation recently we said, you know what, maybe beneficiary designations on that aren't the way to go, although it would certainly help the instance of transferring the money directly to the children at my death. But if I outlive one of those children and that's their 4th, if you will, is a significant amount of money, I want to make sure it goes to the grandchildren. So maybe I'm better off in having my estate be the beneficiary of that policy and let my will control it. So it's a puzzle, and you don't just anymore look to just the will. You need to look at the will and whatever else you have and how you've titled it to kind of make it Like I said, it's just like a big jigsaw puzzle.
Fascinating stuff. It is. It really is. And it's important to be prepared. Nancy Martin, thank you for being our guest today on
My
Circuit
pleasure.
Clerk Presents.
You're welcome.
To talk about wills and probate, a very important topic. Bottom line, be prepared. Thank you very much. My name is Paul Palazzolo, your Sangamon County Circuit Clerk. Thanks for joining us for Circuit Clerk Presents.